Amy Coney Barrett silences Chief Justice Roberts in historic Supreme Court showdown, standing poised in the heart of the Supreme Court chamber. Justice Amy Coney Barrett appeared calm beneath her black robe, framed by the rich mahogany backdrop of America's highest judicial institution. Moments earlier, an unexpected comment had shattered the solemn air. Chief Justice John Roberts had turned to her and said, "Perhaps Justice Barrett, with her limited experience, might consider recusing herself from this constitutional matter." The courtroom froze. Legal analysts, seasoned reporters, and veteran clerks sat stunned by the rare, direct challenge from the Chief Justice to the court's newest member. In that moment of charged silence, no one could have predicted how the next 2 minutes would reshape the dynamics of the Supreme Court for years to come. With composed confidence and a few precisely chosen words, Barrett not only responded, she redefined the moment. Her sharp, measured rebuttal transformed what was intended as a dismissive rebuke into what some now call the greatest misstep of Roberts's judicial tenure. Before we delve deeper into this unprecedented confrontation, make sure to like this video and subscribe to our channel for exclusive insights into the hidden power struggles within America's most influential institutions, the kind the mainstream media often overlooks. To fully grasp the impact of this moment, it's important to understand who these two legal heavyweights are and why this exchange carries weight for every American. Chief Justice John Roberts, appointed in 2005 by President George W. Bush, has spent more than a decade and a half shaping the modern Supreme Court. A Harvard graduate with deep roots in the legal establishment, Roberts has projected an image of moderation and institutional fidelity. Though appointed by a conservative president, he has often sided with the liberal bloc on landmark cases concerning healthcare and immigration, earning both praise and criticism for his centrism. Beneath his composed demeanor lies a strategist focused on preserving judicial legitimacy and, according to critics, the entrenched power structures of Washington. Justice Amy Coney Barrett, on the other hand, symbolizes the ascendant conservative legal movement. Appointed by President Donald Trump in 2020 following the death of liberal icon Justice Ruth Bader Ginsburg, Barrett entered the court with sterling credentials, a former professor at Notre Dame Law School and a respected federal appellate judge. Her nomination ignited fierce political debate, yet her intellect and textualist philosophy quickly positioned her as a formidable force on the bench. The clash between Roberts and Barrett was more than a disagreement over jurisprudence. It was a battle of ideologies, generations, and visions for the court's future. A devout Catholic and mother of 7, Justice Amy Coney Barrett has long been a lightning rod for controversy. Critics have questioned whether her deeply held religious beliefs would unduly influence her decisions from the bench. Yet despite the scrutiny, Barrett has remained unshaken, calm, methodical, and fiercely focused on the law. This particular confrontation, however, wasn't just about her legal philosophy or qualifications. It was about power and a turning point. In a court where seniority often dictates sway, Barrett saw the moment as a chance to assert her intellectual independence and challenge the subtle hierarchy that governs the Supreme Court. For the millions of Americans who had championed her confirmation, this was the moment her judicial backbone would be put to the test. The stakes were monumental. At the heart of the matter was a pivotal constitutional question, one with far-reaching implications for the future of religious liberty in America. Chief Justice John Roberts, aware of Barrett's rising stature within the court's conservative bloc, chose this critical juncture to publicly undermine her, a calculated move meant to reassert his control over the court's ideological trajectory. Tension had been simmering since early that morning, during oral arguments in Fulton v. City of Philadelphia, a landmark case on religious freedom. Barrett had asked a series of sharp, probing questions that hinted at a new framework for evaluating First Amendment claims. Her line of reasoning signaled a potential shift in constitutional interpretation, one that could reshape legal precedent for generations. Roberts, known for his preference for incremental change and institutional preservation, grew visibly uneasy as Barrett's inquiries cut deeper. Her questions weren't just well-informed, they were bold, revealing a mastery of constitutional law that impressed even the most seasoned litigators present. The first real clash occurred when Barrett cited an obscure but relevant precedent from 1887, a case that directly contradicted the modern legal logic Roberts had been championing in similar matters. Justice Barrett, Roberts interjected sharply, his tone clipped and uncharacteristically pointed. The court has long since moved beyond that antiquated line of reasoning. Barrett acknowledged his comment with a polite nod, but didn't back down. She calmly resumed her questioning, unfazed. From the press gallery, journalists exchanged knowing glances. The tension between the court's chief and its newest member was undeniable and highly unusual. As the session wore on, Justice Samuel Alito echoed Barrett's analysis, suggesting that her interpretation provided a more faithful reading of the Constitution's original text. Other justices began to gravitate toward her argument. Roberts's discomfort became increasingly visible as the balance of legal persuasion shifted. But the defining moment came not in public, but behind closed doors, during the justices' private post-argument conference. As Barrett began to articulate her reasoning and outline her proposed framework, Roberts cut her off. "We have established procedures for interpreting these clauses," he said curtly, his tone laced with condescension. It was a direct challenge, not just to her analysis, but to her authority. What followed would reveal Barrett's strength not only as a jurist, but as a leader unwilling to defer to tradition at the expense of principle. Witnesses would later describe Chief Justice John Roberts's tone as unusually sharp, even uncharacteristically hostile. "This court has developed these standards over decades," he declared. When Justice Amy Coney Barrett attempted to interject, Roberts pressed on, speaking over her, a rare and jarring breach of the Supreme Court's traditionally guarded collegiality. Justice Clarence Thomas, the court's most senior associate justice, lifted an eyebrow in quiet disapproval but said nothing. The tension from the justices' private conference quickly spilled into the public session later that afternoon. In a separate case discussion, Roberts made what appeared to be a premeditated remark. Locking eyes with Barrett, he said, "Perhaps Justice Barrett, with her limited experience, might consider recusing herself from this constitutional interpretation. After all, these complex frameworks were developed while she was still teaching 1L basics in law school." A wave of gasps swept through the courtroom. In living memory, no Chief Justice had so directly questioned a colleague's competence, let alone in open court. Courtroom sketch artists hurried to capture the unfolding drama. Justice Sonia Sotomayor, despite often opposing Barrett ideologically, looked visibly unsettled by Roberts's breach of protocol. Justice Elena Kagan focused tightly on her notes, clearly avoiding eye contact. Justice Brett Kavanaugh shot Barrett a glance of concern. The air was heavy with disbelief. Barrett sat motionless, composed, her face unreadable as Roberts continued, suggesting that she might benefit from more observation before contributing assertively to constitutional interpretation. Then, as Roberts concluded, the room fell into a long, brittle silence. All eyes turned to Barrett. She calmly straightened the pages in front of her, inhaled slowly, and raised her gaze to meet the Chief Justice's. When she finally spoke, her voice was level, clear, and unwavering. "Thank you, Chief Justice Roberts, for your concern regarding my experience," she began, her tone polite but unmistakably firm. "I believe my years teaching constitutional law have well prepared me for this role, just as your time in private practice prepared you for yours." The remark landed with precision. Though subtle, it carried the weight of a sharp retort, a quiet reminder that unlike Roberts, who had no judicial experience before becoming Chief Justice, Barrett had served on the federal bench and taught constitutional law for years before joining the court. She continued, "That said, I believe we would all benefit from turning our attention to the actual text of the Constitution, rather than relying exclusively on interpretive frameworks that have evolved over time." Then, reaching for a well-worn copy of the U.S. Constitution, which she routinely keeps at her side during sessions, Barrett began quoting, unaided by notes, from 5 distinct sections. With impressive clarity, she connected each passage to the matter under debate, weaving together a compelling constitutional argument. "And perhaps most relevant to our discussion today," she said, steady and resolute, "is the original understanding of the First Amendment's protections for religious liberty, as articulated by James Madison in his 1789 address to Congress." She then proceeded to recite Madison's statement from memory, a lengthy and nuanced paragraph that few modern jurists could quote in full. Legal scholars present later confirmed her recitation was flawless. Concluding her remarks, Barrett looked once again toward the Chief Justice and said, "In light of these foundational texts, I must respectfully disagree with the suggestion that a commitment to original meaning reflects inexperience. On the contrary, I believe it reflects judicial discipline." In that moment, The courtroom remained suspended in silence, not out of tension, but reverence. Barrett had not only defended her place on the bench, she had claimed it with intellectual force and constitutional authority. Even those who had questioned her appointment now saw a jurist ready to shape the court's future, not from the sidelines, but from the center of its most consequential debates. The courtroom held its breath. Justice Clarence Thomas, typically silent during arguments, nodded in visible approval. Justice Elena Kagan, long regarded as a liberal counterweight to Barrett's conservatism, glanced up from her notes, a flicker of newfound respect in her eyes. But Barrett wasn't done. What came next wasn't just a powerful rebuttal. It was a strategic and devastating flourish. In the most incisive moment of her response, Barrett cited a decades-old law review article authored by none other than Chief Justice John Roberts himself. In that piece, written early in his legal career, Roberts had championed a judicial philosophy rooted in strict adherence to constitutional text, the very approach Barrett had just defended. As a young attorney, Barrett said calmly, turning her gaze once more to the Chief Justice, "You eloquently wrote that this court's highest duty is fidelity to the text, even above institutional precedent." She paused, then added, "I've always admired that principle. I'm simply striving to honor it, in service to both the court and the Constitution." A subtle smile tugged at the corner of Justice Samuel Alito's mouth. Across the bench, Roberts, famed for his rhetorical poise and rapid-fire intellect, was uncharacteristically silent. The courtroom's most verbally agile figure now sat still, the force of Barrett's words leaving him visibly shaken. His earlier condescension had evaporated, replaced by a stunned and speechless expression. Later, a veteran Supreme Court correspondent would call it the most elegant dismantling of a Chief Justice in modern history. No shouting, no theatrics, just measured logic, historical precision, and unmatched constitutional clarity. In a few deliberate minutes, Barrett had not only neutralized Roberts' attempted rebuke, she had elevated herself into the court's intellectual forefront. Roberts finally broke the silence. "Thank you, Justice Barrett, for that comprehensive response," he said, his voice subdued, lacking its usual surety. "The court will take all perspectives under advisement." But those in attendance knew what they had witnessed. In under 3 minutes, Amy Coney Barrett had gone from being seen as the court's newest justice to one of its most formidable constitutional minds, not through force, but through the unshakable discipline of originalist interpretation. The ripple effect was immediate. Legal blogs lit up within hours, dissecting her response line by line. The hashtag Barrett Brilliance began trending as law students and scholars from across the ideological spectrum weighed in. Clips of the exchange exploded online, drawing over 5 million views by nightfall. Even inside the marble halls of the court, the atmosphere had palpably shifted. According to insiders, following the session, Justice Clarence Thomas quietly approached Barrett and said, "That was long overdue." Known for his restraint, Thomas was later seen smiling as the two walked together back to their chambers. Justice Alito reportedly told one of his clerks, "That will be taught in constitutional law classes for decades." Justice Sonia Sotomayor, a frequent ideological opponent of Barrett, was overheard telling her staff, "Agree or disagree with her conclusions, that level of constitutional command deserves respect." The next morning, observant reporters noted something peculiar. Chief Justice Roberts arrived at his chambers earlier than usual, and he was carrying a stack of books on constitutional history in a quiet yet telling gesture. A Supreme Court staffer revealed that Chief Justice John Roberts had recently requested the complete writings of James Madison from the Library of Congress. It was a clear signal. The Chief Justice was revisiting the very constitutional foundations that Justice Amy Coney Barrett had cited with ease and authority just days earlier. But that was only the beginning. Within the Supreme Court itself, the atmosphere had shifted dramatically. At the next public session, just 48 hours after their dramatic exchange, Roberts was seen leaning toward Barrett before proceedings began, quietly consulting her with what court observers described as a visible sense of deference. For a Chief Justice known for carefully guarding his institutional authority, this subtle change in posture spoke volumes. That day, when Barrett posed questions during oral arguments, Roberts refrained from interrupting, a noticeable departure from previous sessions. And behind closed doors, during the justice's private conference, an even more extraordinary moment unfolded. Roberts invited Barrett to present her analysis on a complex jurisdictional issue before he offered his own view. In the rigidly hierarchical world of the Supreme Court, where junior justices traditionally speak last, this was a profound reversal of protocol. Justice Elena Kagan, sources say, was visibly taken aback by the move. Legal analysts quickly noted ripple effects. Barrett, the court's most junior member, was unexpectedly assigned the majority opinion in two major upcoming cases, a rare responsibility usually reserved for more senior justices. Insiders suggested the decision came directly from Roberts himself, signaling not only a gesture of reconciliation, but also a tacit acknowledgement of Barrett's growing stature as a constitutional authority. Even more significantly, elements of Barrett's textualist framework began to surface in opinion drafts circulated by other justices. In one partial concurrence, Justice Stephen Breyer, often on the opposite ideological end, incorporated aspects of her analytical style, lending unexpected weight to her influence. Media reaction fell along predictable partisan lines. Conservative outlets heralded the moment as a triumph. Fox News declared, "Barrett proves her critics wrong," while National Review ran the headline, "Constitutional brilliance silences doubters." One conservative commentator remarked, "Barrett just reminded the establishment why outsiders often become the most powerful insiders." But what surprised many was the reaction from the legal left. The American Constitutional Society, typically aligned with progressive jurisprudence, devoted an entire issue of its monthly newsletter to dissecting Barrett's methodology. At Yale Law School, professors amended their syllabi to include a new section titled New Perspectives on Original Meaning, the Barrett Method. Even Harvard Law professor Alan Dershowitz, often critical of Trump-appointed justices, admitted on CNN, regardless of ideology, Justice Barrett's command of constitutional text and history is nothing short of extraordinary. On MSNBC, a panel of progressive legal experts reluctantly echoed the sentiment, acknowledging that Barrett had demonstrated remarkable intellectual discipline and clarity. In the New York Times, a well-known progressive scholar wrote, "While I disagree with many of her conclusions, Justice Barrett applies her textualist method with a consistency and depth that cannot be ignored." And then, perhaps the most surprising development of all, Justice Elena Kagan, during oral arguments, openly cited Barrett's framework, noting that Justice Barrett's focus on textual precision may help clarify our approach in this instance. It was a quiet, but unmistakable sign that Barrett's influence was beginning to cross ideological lines. Inside the White House, the moment didn't go unnoticed. President Biden, a former chairman of the Senate Judiciary Committee and longtime student of constitutional law, reportedly watched a recording of the confrontation. "That," he said to aides, "is why the confirmation process matters so much. That level of constitutional knowledge is exactly what Americans deserve on their highest court." Sources indicated that Biden instructed his judicial nominations team to place greater emphasis on constitutional textual expertise moving forward. And the ripple effects reached beyond the Supreme Court. During recent Senate judiciary hearings, both Republican and Democratic senators began referencing the Barrett standard when questioning judicial nominees. At one hearing, Senator Lindsey Graham held up a pocket constitution and challenged a nominee. "Can you recite the clause that establishes judicial power?" A direct echo of Barrett's viral moment. Law schools across the country reported an uptick in interest in constitutional law and originalist theory. At Georgetown, the newly formed Barrett-Scalia Textualist Society saw its membership triple in just a few weeks. Columbia Law School's dean commented, "We're witnessing unprecedented enthusiasm for originalist methods, even among students who don't necessarily agree with their typical outcomes." What began as a tense courtroom exchange has now become a pivotal moment in modern American legal history. Amy Coney Barrett didn't just defend her jurisprudence, she redefined her role on the court. And in doing so, she shifted the gravitational center of the Supreme Court itself. For Justice Amy Coney Barrett, a moment of courtroom confrontation transformed her public image overnight. Once cast as a polarizing appointee, she quickly emerged as a jurist of undeniable intellectual power and constitutional clarity. In a striking shift, The Atlantic published a profile lauding Barrett as a constitutional heavyweight, crediting her with earning a place among the most influential legal minds to have served on the court. Time magazine named her one of the 100 most influential people of the year, and in a surprising twist, it was liberal Justice Elena Kagan who penned the profile. Kagan acknowledged that Barrett's contributions had already begun to reshape how the Constitution is debated and interpreted across the legal landscape. The momentum didn't stop there. Major publishing houses engaged in a bidding war for the rights to Barrett's judicial memoir, with advances reportedly reaching 7 figures. Law schools began incorporating the Barrett methodology into their constitutional law curricula, treating her approach as a distinct interpretive school. The University of Chicago Law Review devoted an entire issue to her growing body of jurisprudence, with legal scholars from across the ideological spectrum offering deep analysis of her influence. Perhaps the most powerful signal of Barrett's broader cultural impact came from women in the legal field. Applications to Notre Dame Law School, where Barrett had previously taught, rose by 35% in the following academic year. The Women's Legal Association at Harvard Law School, despite ideological differences, invited her to keynote their annual conference. Whatever your stance on her rulings, their statement read, Justice Barrett is a living example of female excellence in a field long dominated by men. Young women in courtrooms across the country began wearing small Barrett-inspired pins, not as political endorsements, but as statements of intellectual aspiration. Meanwhile, the effects of Barrett's influence began surfacing inside the very institution she had reshaped. At the next State of the Judiciary address, traditionally delivered by the Chief Justice, observers noted a shift in John Roberts' tone. He spoke at length about the court's duty to adhere to constitutional text and the importance of grounding legal interpretation in founding-era principles. Analysts widely interpreted the speech as a quiet endorsement of Barrett's originalist philosophy, a notable departure from Roberts' historically pragmatic approach. Court watchers began to detect subtle changes in Roberts' opinions as well. In a major separation of powers decision the following term, his majority opinion contained more references to original public meaning and historical context than in any of his previous writings. Some legal scholars suggested that Barrett's influence was not just shaping outcomes, but elevating the court's jurisprudential rigor. In a rare moment of candor during a judicial conference at Georgetown Law, Roberts publicly acknowledged the importance of fresh perspectives that challenge our assumptions. Though he didn't mention Barrett by name, those in attendance understood precisely whom he meant. In 3 decades of studying the Supreme Court, said one prominent constitutional scholar present, I've never seen a junior justice so rapidly redefine the intellectual direction of the institution. The ripple effects were immediate and far-reaching. The court began granting certiorari to more cases involving core constitutional questions, many centered on textual interpretation and original meaning, areas in which Barrett's voice carried considerable authority. Legal briefs submitted to the court soon reflected this shift. Attorneys began emphasizing textualist arguments and originalist foundations, recognizing that to be persuasive in this new environment, they had to engage with Barrett's method, whether or not she was the justice they were addressing. One partner at a major D.C. law firm offered blunt advice to his colleagues, if you're arguing before this court, you have to address Barrett's framework. Ignoring it isn't an option anymore. What began as a personal challenge between 2 justices had evolved into something far greater, a defining moment in modern constitutional interpretation. The Roberts-Barrett exchange raised a question that now sits at the center of American jurisprudence. Should fidelity to the text and original public meaning be the judiciary's highest aim, as Barrett contends? Or should precedent and evolving interpretations continue to guide legal reasoning, as Roberts has long maintained? That tension between tradition and evolution, between original meaning and modern consequence, will shape not only the legacy of Amy Coney Barrett but the direction of American law for generations to come. In legal circles, a new term has taken root, the Barrett Revolution. Constitutional scholars have begun using the phrase to describe the swift and far-reaching impact of Justice Amy Coney Barrett's approach to jurisprudence. Her influence, some argue, rivals the seismic shift brought by Justice Antonin Scalia in the 1980s. But what makes Barrett's rise even more remarkable, experts say, is the speed with which she's realigned the court's intellectual foundation. Amy Barrett hasn't just added her voice to the court, she's shifted its center of gravity, noted a prominent legal historian at Stanford. It's not just her individual brilliance. It's how quickly the rest of the institution is orbiting around her interpretive methodology. The effects have rippled far beyond the marble steps of the Supreme Court. On Capitol Hill, legislative aides confirmed that lawmakers are now actively considering how Barrett might interpret new bills. We're literally asking, would this language hold up under Justice Barrett's textual scrutiny before finalizing legislation? One senior staffer admitted. That's how much influence she already commands. The true measure of Barrett's impact came in the court's next major ruling. When the opinion was published, legal analysts were stunned to find that the majority had adopted Barrett's textualist framework nearly word for word. Even more astonishing was the makeup of the justices who joined it, a cross-ideological coalition of both conservatives and liberals. It was a clear signal. Barrett's methodology wasn't just resonating on the right. It was forging a new path forward for the court itself. At that pivotal moment, Amy Coney Barrett ceased to be merely the court's newest appointee. She became one of its most influential voices, a leading force in constitutional interpretation whose fidelity to text and original meaning is reshaping how the nation's highest court reads the law. But perhaps the most powerful message wasn't about political victory. Barrett's triumph was not a win for conservatism or a blow to progressivism. It was a demonstration that intellectual rigor, grounded in constitutional principle, still holds sway in American institutions. In an era often dominated by partisanship and public spectacle, Barrett proved that clarity of thought and depth of knowledge can still transcend ideology. Looking ahead, her influence is only expected to expand. With major upcoming cases on religious liberty, separation of powers, and the limits of federal authority, Barrett's approach is poised to serve as the guiding framework in some of the court's most consequential decisions. As one law professor put it, "We're all living in Barrett's constitutional universe now, whether we acknowledge it or not." The only question that remains is how this new dynamic will evolve. Will Chief Justice John Roberts attempt to reassert control over the court's direction? Or has the balance of power permanently shifted toward Barrett's originalist worldview? One thing is certain. The future of American constitutional law is being written, and Amy Coney Barrett is holding the pen. Stay with us as we continue to follow the evolution of the court and the jurisprudence shaping your rights, freedoms, and the very foundations of American democracy. Subscribe now and turn on notifications so you don't miss our upcoming special report, The Barrett Court: How America's Newest Justice is Rewriting the Rules of Constitutional Law.